Hello everybody, I'm Nicholas Patrick. I'm a pro bono partner here at DLA Piper, and I'm very honoured to be joined on stage today by my friend and colleague Lisa Dewey, who's also a pro bono partner here at DLA Piper, based in our DC office. And on behalf of all of the partners here and the pro bono team at DLA Piper, I want to welcome you today to this inaugural Access to Justice and Technology Summit. DLA Piper is a firm that cares really deeply about access to justice. We take our pro bono practice very seriously. We invest a lot in our pro bono practice. And we're also a firm that I think is embracing technology and quite committed to radical change and staying ahead of the curve in terms of the changes that technology will inflict on our profession. The idea for this summit came about a couple of years ago when I was at another conference and I heard Kate Fazio speaking on the technology that was already being used around the world to promote access to justice. And I was really blown away by her presentation. I was also shocked and embarrassed about really how little I knew about what technology was out there and what technology was being used to promote access to justice for the most vulnerable people in the world. And when I heard that presentation, I had, in addition to being inspired, shocked and embarrassed, I also had a moment of clarity where I really saw quite clearly that technology was going to do more to promote access to justice over the next decade than pro bono had done over the last decade. And so I felt it was really incumbent upon myself and also DLA Piper and my team to learn more about the technology that was out there and how we could use it to support our clients. I also think big law firms have an important role to play here, since we have the resources to invest in technology, and we need to do that through our pro bono practices for the benefit of our pro bono clients. But also I think we need to make sure the technology that we're developing for our commercial clients is made available to our pro bono clients and also to the non-profit organisations we work with. So really, we put this summit together for ourselves, to educate ourselves and to find out more, but we're very glad that 200 of you wanted to come on that journey with us and are here today. And so again, I just welcome you all. And without further ado, I will now introduce our first speaker, Richard Susskind. Professor Susskind is an author, speaker, and independent advisor to major professional services firms and national governments, including DLA Piper, by the way. And his main area of expertise is the future of professional service, and in particular, the way in which the IT and internet are changing the work of lawyers. So, Professor Susskind, welcome.
Thank you very much. Good morning, ladies and gentlemen. I think, first of all, we must congratulate DLA for bringing together so generously such an important group of people to discuss such an important subject. It's heartwarming to see law firms taking an interest in access to justice and, of course, the use of technology. So thank you very much to DLA, I'm sure, on behalf of all of us. The program you've put together is formidable, and we're very much looking forward to the day's activities. I'm speaking at you, as it were, for about half an hour, so I don't think, unfortunately, there'll be time for questions. And when we were discussing this, I was reminded of one of my favorite stories about Albert Einstein, the great physicist who apparently gave a wonderful lecture many years ago. And he got very friendly with the chauffeur who used to drive him to and from the various places at which he was speaking. And one day, the chauffeur's driving along in the car, and Einstein's sitting in the back seat, and the chauffeur looks in the rear view mirror and says, "Professor Einstein, you really are a remarkable man. What I find amazing is not simply the complexity of your theories, and clearly they are very sophisticated, but it's your ability to break these theories down into simple, straightforward propositions. That's what I find especially amazing. In fact, so clear are you, and so many times have I heard you, that I think I myself could give one of your talks." So Einstein's sitting in the back of the car. He says, "Well, it's funny you should say this, because I'm getting rather bored of giving the same talk again and again. So why don't we try an experiment? Why don't we reverse roles? Just before we arrive at the lecture theatre, I'll get out of my clothes, I'll get into your chauffeur's uniform, and I'll stand at the back of the hall. As you would normally do, you can get into my clothes, we're about the same size, and you can give the talk. What do you think?" Chauffeur thinks this is a wonderful idea. They duly arrive at the lecture theatre. Einstein gets out of his clothes, climbs into the chauffeur's uniform, stands at the back of the hall as the chauffeur would normally have done. And the chauffeur, in Einstein's clothes, stands at the front and gives this phenomenal lecture. The crowds are going wild. But what they hadn't banked on, of course, was question time. And this very eminent physicist stands up and asks this impossibly difficult question. The chauffeur's eyes glaze over, but then they light up. He said, that question's so easy, I'm going to ask my chauffeur at the back of the hall to answer it. And it was occurring to me, this story, because there's so many eminent people in the audience that had there been difficult questions, I'd have been inclined to throw them back to the chauffeurs amongst you. Here's what I'd like to talk to you about over the next half hour or so. 6 issues. I want, in a very summary way, to say a little about the problem that brings us together. Then to suggest to you the kind of mindset we might usefully have in thinking about the future. After that, dip only for a few minutes into technology, just to remind ourselves about how radically changing times we live in. Then focus on the question of access to justice. This, I hope, is all setting us up for the rest of the day. And I have a rather wider conception of access to justice I'd like to share and introduce to you. Penultimately, but really the heart of the presentation, is to talk about online courts. I've been involved in technology and law since the early 80s now, and I'm pretty convinced that in online courts we have a better set of answers to access to justice problem than we've ever had before. So I want to conclude by asking whether or not we really do have something very important within our grasp here. So as for the problem itself, there's many ways of expressing it. I'm sure Hazel and others will go into far greater detail, but a couple of stats that jump out the page to me. One, that only 46% of human beings live under the protection of the law, according to OECD. In my travels, I've found quite staggering backlogs in some court systems. 100 million cases in the court systems of Brazil, 30 million in India, for example. According to our friends in the Hague Innovation Centre, annually 1 billion people need basic justice care, but they say in many countries close to 30% of problem owners don't even take action. As for legal aid, so controversial and understandably a controversial issue, 1/3 of 106 countries reviewed in a major study by the UN have not yet enacted specific legislation in legal aid, and the demand for legal aid in civil cases is largely unmet in most countries. But this, in a way, this slide before you is the proposition, or the set of propositions that have agitated me most, that even in the most advanced court systems in the world, of which, for example, England and Wales is an illustration, most civil disputes cost too much, they take too long, the process is unintelligible for non-lawyers, and the whole thing feels out of step in an increasingly digital society. Lord Dyson, the master of the rolls for many years, once put it very well in respect of England and Wales. He said any system that's got a 2,000-page user guide has got a problem, and he's referring to our civil procedure rules. So we find ourselves in a parlous state, I believe, that in a very important sense our justice systems, even the most advanced, are creaking, and we need, it seems to me, to think differently about how we offer access to justice. And I want to say a little bit about mindset in this context. I was invited 18 months ago to give a presentation to 2,000 neurosurgeons in Boston, scary audience. And they asked me to be controversial. So my opening line was this. I said, patients don't want neurosurgeons. Slight gasp in the audience. I said, patients want health. Now, for a particular type of health problem, I've no doubt you're the best answer. But when you asked me, I said, to come to you to speak about the future of neurosurgery, I'm not sure we're asking the right question there. Because surely the question we should be asking is how in the future will we sort out problems to which today neurosurgeons are the best answer? I think in 50 years' time, I said, I don't know, it's 30, it might be 70, but we'll look back and think it's unbelievably primitive that we used to cut heads open. Because the future of healthcare is non-invasive. That's the way the healthcare industry is working. And so to ask the question, to fixate on what's the future of surgery, seems to me to ask the wrong question, as I say. And I think it's the same with the courts. We tend to have this sense that the question we should be asking ourselves is, what's the future of our court system, rather than asking ourselves how in the future will we be resolving disputes mechanisms might we have in place that might bear no recognition to the conventional court system. So it's not a question, it seems to me, in thinking about the future, about how do we preserve and enhance what we do today. At times of such great stress and strain, we probably need to think more fundamentally. And this is just a minor plug for a book that I've written on online courts, which is coming out later this year. I've been preoccupied with online courts for a number of years now. And what I've tried to do is take a step back and think systematically and extensively about how this might radically affect the way we offer access to justice. And I want to give you a flavor of some of my thoughts in that book today. But underpinning this is this whole idea of what I call outcome thinking. We've got to stop thinking in terms of perpetuating, enhancing, improving our current systems. Instead, we have to focus far more on what outcomes we require from a public dispute resolution system and how in the digital age we might deliver these entirely differently. And just to give you a little bit of history there, I said I've been involved in this since the early 80s. This was my first attempt as an undergraduate to look at the question of computers in courts, computers in the judicial process. Some of you in the room will be old enough to remember something called letraset, which were little transfers you put on to try and, if you were typing a page, you only had on a typewriter one size of typeface. And so if you wanted something bigger, you had to use these transfers. So computers in the judicial process was put on by transfer. And I noticed as an undergraduate, I wasn't actually cautious enough even to put it on straight. But my aim then and now was to think, I wonder if there might be different ways of doing all of this. So let's talk about technology and introduce a distinction that I think is fundamental to this discussion and all discussions of the future of technology between automation and transformation. Automation is what many people have in mind when they think about technology. You think of some process or activity, set of tasks, and you think, how can we automate, systematize, streamline, improve what we already do? You take some kind of inefficient pre-existing process and you apply technology to it. You automate it. And that's been really the dominant approach to technology in the court system for the last 40 years or so. We've tried to automate our current practices. But we're seeing across so many other sectors an entirely different conception of technology. And that's a conception where technology is not used to sustain and enhance our old ways of working. We know all the terminology. It's about disruption. It's about replacement. It's about transforming, fundamentally changing underlying ways of working to deliver the same outcome. And what I'm suggesting to you today is that our orientation, our mindset, should be towards outcomes and transformation rather than the automation of our traditional ways of working. Another observation to make about our systems, and people express this in a whole bundle of different ways. You hear endless chatter about artificial intelligence, machine learning, blockchain, and so forth. And these, of course, are the interesting technologies of our day. But in 5 years' time, we're probably talking about other technologies. The more fundamental point here is that our systems are becoming increasingly capable. They're taking on more and more tasks, many of which historically we thought were the exclusive preserve of human beings. And at once, I think, both exhilarating and disconcerting is this notion that there's no finishing line when it comes to technology. Not only is the pace of change accelerating, but one can imagine, say, by 2025, our lives will be transformed by technologies that haven't yet been invented. It's not just that we're improving current technologies, we're seeing the introduction of resources and facilities that were beyond our imagination not many years ago. And no one in Silicon Valley, no one in China, no one in South Korea is dusting their hands off and saying, job done. Let's plateau for a while. Enough's enough. In the world of technology, it seems that enough is not nearly enough. And if you think of the combined intellectual and financial capital going into the world of technology, it's unprecedented. We live at a time of more rapid technological progress than humanity's ever witnessed. And to think that this might not have some impact in the way that lawyers and courts work, it seems to me is folly. But more than that, it seems to me we're failing to grasp an opportunity to deliver the outcomes we require in new ways. So a little about access to justice. The term access to justice, I think, gained particular popularity in this country in the mid-90s when Lord Wolfe's reports on civil reform bore this term as the title of his reports, his Access to Justice reports. And access to justice then, and for many judges now, when people talk about improving access to justice, they're talking about improving access to the courts, access to dispute resolution. But I think we can be far more ambitious than that, and should be. That surely a great justice system doesn't just resolve disputes and support the resolution of disputes. Surely it should help us also contain disputes. I think one of the biggest problems for our justice system is that institutionally and commercially, the incentives are in place when disputes arise, both for courts and lawyers to continue, often to escalate disputes, whereas the priority, I think, for a great justice system should be to contain disputes. It's in the interests of parties that disputes are contained, not exacerbated by process. But even before we get there, surely we should want a justice system that encourages us not just to resolve or contain disputes, but to help us avoid them arising in the first place. I often call this putting a fence at the top of the cliff rather than an ambulance at the bottom. And yet when most people are talking about change to the justice system and to the court system and to lawyers, they're talking about equipping that metaphorical ambulance a bit better, about getting it to the scene a bit quicker. They're not talking about putting that fence up. But if you think commercially, I've never met a chief executive who prefer a really large dispute well resolved by a big team of lawyers and by extended court process to not having a legal dispute at all. That's not the way the normal non-legal mind thinks. Most people want to avoid disputes rather than have them resolved by complex, expensive, forbidding process. And therefore, it seems to me that it's part of the responsibility of a modern justice system to have in place processes that help us avoid disputes as well. And then there's another step, which is perhaps beyond the remit of the court system, but what I call legal health promotion. Those of you who remember your jurisprudence will remember the book Hart's Concept of Law, where he distinguished between duty imposing and power conferring rules. And he made the point that most people, when they think of the law, tend to think of it as duty imposing, that it obliges, it prohibits, it requires. And he was saying that so much of the law is actually empowering and facilitative. It allows us to make contracts. It allows us to get married. It allows us to conduct our lives and our businesses in the way we do. And yet so much of our conception of court and legal practice is about imposing duty. And so just as in medicine, where we talk about legal health promotion, where we say, for example, that people should exercise 3 times a week, not just because it helps your cardiovascular system, it also helps you feel a lot better. Well, surely similarly in law, if the law does indeed confer all sorts of powers and facilities, surely a great justice system will assist people in knowing of what these powers and facilities are. And today, for most people, the law is dreadfully opaque. So I plant this as a set of thoughts that I follow through in my book, but a set of thoughts for today that we shouldn't be thinking, if we're talking about access to justice, in too restrictive terms. We can imagine it, at least a justice system that supports a wider set of offerings. Another thing that I wanted to say, again by way of introduction really to the day, follows from the work of Amartya Sen, who's a Nobel Prize winner in economics. And he's written this wonderful book called The Idea of Justice, which I think generally agreed to be probably the best book on theory of justice since John Rawls' book, A Theory of Justice, was written, 50 years ago. And Sen introduces a very interesting distinction in the context of philosophers, but I think it applies to lawyers as well, between comparative and transcendental conceptions of justice. So the transcendentalists are those people who are preoccupied when they talk about justice, about achieving some kind of perfect form of justice system, about establishing perfect institutions that will deliver justice. And they get very frustrated, of course, because, and it's often a romantic view that I think is echoed by so many lawyers in practice, who when you talk about change, will discuss that change by reference to some perfect system that doesn't exist. It's a classic lawyer argument. They'll look at a system, a new technology, and say, well, that doesn't do X, Y, or Z. And then you have to remind them, well, the current system doesn't do X, Y, and Z. Remember Voltaire says the best is the enemy of the good. It's so true in law that what we tend to do, lawyers and legal academics as well, we tend to want to object So you hear an idea for a reform and improvement, and you reject it because it's not perfection. The comparativists, on the other hand, have a different preoccupation. Their preoccupation, in Sen's words, are to remove manifest injustices. And I think that's a far better motivating force, that we shouldn't be chasing abstract conceptions of perfect justice that do not exist and are probably unrealizable. Instead, our collective aim should be to remove the manifest injustices that are inherent not just in society, but in our justice system. So my drive is towards improvement rather than perfection. It's not when I talk about online courts that I think an online court on every occasion will deliver a better output than the Lord Chief Justice sitting in courtroom 4 in the Royal Courts of Justice. What I'm saying is we have grave problems of inaccess to justice, and here's a solution that seems to me that improves upon what we have today, which is a system that's too costly, too time-consuming, unintelligible for the non-lawyer, and as I say, out of step in the digital society. So in the name of justice, I find, and it's on my mind because I'm appearing for the Justice Committee next week, but in the name of justice, I fully expect that critics are missing the opportunity to reduce injustice. And that paradox is an important one of our age. A little bit about online courts now. The fundamental question here in the spirit of outcome thinking is court a service or a place? Do we really need physically to congregate together to resolve our differences? Or might we in a digital society manage to resolve these differences electronically? I've been involved with this since, actually my interest stems to the mid-90s, but in 2014-15 I chaired the group of the Civil Justice Council that came up with the idea for England and Wales of online courts. In a nutshell, what we're talking about here is for low-value disputes, at least for now, a simplified public court service, using online techniques as an integral part of the system, not an add-on, it's a fundamental part of the system, delivering, we hope, affordable, quick, intelligible service, enabling non-lawyers to conduct their own cases, providing tools for these non-lawyers to help them assess and formulate their claims, the ability not the requirement to appear and submit evidence orally, but to submit evidence and arguments online. But cases are not immediately handled by judges. They're also handled, in the first instance, by case officers. And then in a process which is asynchronous, judges online will review evidence and arguments and come to their decisions in cases that are deemed appropriate by the case officers. So it's a simplified electronic procedure. I look at it in a different way as well, that there's 3 tiers to this. There's the determination by the judge, which we can call online judging. And then there's 2 other facilities. When one first has a case, there's these systems that help you evaluate and understand your claim and the options available to you. And then there's a process of facilitation by the case officer or in due course electronically that helps you decide whether or not it makes sense to proceed or whether or not to judges or whether or not you might negotiate or settle without a judge. I call that the extended court. And the philosophy here is technology allows us to extend the remit of the traditional court system. Now, many people say, well, surely the court system's just there to offer judges deciding cases. I get online judging, but all this other stuff, that's not for a court system to do. And I say, why not? Why not in a digital world as every other area, every other market or sector extending the scope of and remit of our activities? Why can't we do that with courts as well? So the shift here is from the presumption that all disputes before courts should be held in a physical space to the reverse, that by default, in due course, cases will be conducted online unless there are compelling reasons to assemble in a courtroom. This is now enshrined in our white paper in this country, Transforming Justice. The community of lawyers and enthusiasts for online courts is growing. We had a great hackathon in 2017, and in this very room, actually, last year we held the first international forum on online courts. There's other great examples, and you'll hear from Shannon, which is the leading example in the world, about what's going on in civil resolution tribunal. But in thinking about online courts and writing about them, and without being melodramatic, I think we might have found the answer here. at least to part of the question of access to justice. And I had a last-minute change of mind as I wrote the book. I thought in the first instance the most fundamental aspect of all of this was online judging. The idea that you wouldn't need judges to come into courtrooms. That actually I see something quite different. What's really significant is the enhanced courts. The idea that technology can allow non-lawyers to learn far more about the law and their position, and perhaps to resolve their disputes without recourse to judges at all. Remember again, only 46% of people live under the protection of the law. Remember these staggering backlogs. Here's the fundamental point. There's a gulf between people understanding their rights and enforcing these rights. And this hadn't really occurred to me so clearly until I started writing about it, this gulf between understanding rights and enforcing rights. And it's a terribly difficult one to bridge. Now, I, in 1996, I think to some extent set the hair running in all of this and saying, look, the answer to access to justice problem is websites. It's public legal education. It's law students being more involved, delivering pro bono services. It's consumer advice. I now no longer think that's the case. Because what you have, even with, and there's lots of people in the room doing fantastic projects in this area, even if we deliver great websites, even AI-based diagnostic tools which tell everyone their legal position, the reality is knowing your legal position without actually having any kind of institutional heft behind it is like a diagnosis in medicine without a treatment. You know what's wrong, but there's nothing you can do. Imagine if you went to the doctor and say, here's your problem, there's now nothing we can do. We can be very precise about your diagnosis, but we can't help you. That's a little like using all these websites to bring perfect clarity to people's legal problems, but actually saying there's nothing actually we can do to help you enforce. Because what we know is that simply having a knowledge of your legal rights without any other support completely lacks teeth. What you need, and what we've needed historically, is not websites and all that. We need lawyers and courts, because it's the shadow of the coercive power of the state that translates rights into, for example, compensation. There is little point, and we've all, I'm sure, personally suffered in knowing one's entitlements without being able to enforce these entitlements. It's that lawyer's letter that changes the behavior. And as I say, hanging behind that, it's the shadow of the state. But we know that lawyers and courts are largely unaffordable to most people. And therefore, the answer, in my view, is to bridge this gap through online courts. That's what can give us the institutional traction that lawyers give when they advise their clients. That's what can give us this heft. That's what can empower us to move from having an entitlement to actually changing the behavior of others. That's what can give us, it seems to me, affordable, quick, intelligible resolution of disputes, and it's all backed by the state. This idea of the disempowered individual who, for example, is in dispute with the insurance company, the airline company, they know they're entitled, but the delaying tactics, and worse from others, because there's no real heft. The minute the lawyer gets involved, there's a change. And what we saw, and it's so clear with the introduction of online civil money claims and its predecessor systems, is that if you go online and you can actually fill out a form, and the person with whom you have a difficulty received some kind of court document, that changes behavior. That bridges the gap. That provides this institutional heft and traction, the teeth, the bite that we require. And globally, I think there's something interesting going on here as well. Isn't it really weird we live in a world where more people now have access to the internet than have access to justice? But on the other hand, does this not provide us globally with a platform? Does this not provide us a platform to offer support to people who've no realistic access to justice nor protection under the law? And the thought I want to leave you with, and it's preoccupying me almost day and night just now, is what our world would be like if we could introduce online courts across the world. I've been doing, for different reasons, a lot of work in Africa, in 12 different countries there. And when you just see the powerless state of so many justice systems, court systems in developing countries, you often get representatives from these countries coming to this country saying, we'd love to learn more about your justice system, your court system. What they have in mind, it seems, is introducing a substantially 19th century system to emerging jurisdictions. And my proposition is, well, actually, why don't we just leapfrog all of that? Why can't we have a concerted international effort to introduce online courts? Now, I know all the objections to online courts, but I want to refer to Voltaire and Sen again. It would be wildly better to have online courts that deliver the benefits that I, and I'm sure Shannon and others will anticipate today, than to have the nothing we've got just now. So what about an international effort to make it an expectation of civilized societies that they have these online courts as a facility? It's not wildly absurd to suggest this, given the rapid uptake of the internet as that platform. But we can do more than that. What about if we got together and actually designed an adaptable global platform for the introduction of online courts? You don't just say to these visitors, you really should have online courts. We could actually, as an international initiative, develop a standard adaptable platform that could allow the introduction of online courts in months rather than years. Here's a rapid way to help self-represented litigants around the world, and here's a rapid way to encourage jurisdictions to embrace the law. There are so many emerging economies who are teetering in the brink just now, who would like more fully, more comprehensively, more meaningfully to embrace the rule of law. They don't have the institutions, they don't have the systems and processes to do so. In a sense, what I'm suggesting is we can perhaps pre-package some of that, make it sufficiently adaptable to allow for particular rules, procedures, and so forth. But what a great kickstart to the introduction of a better system of offering access to justice. And a great transparency there as well. People often say one of the great difficulties with online courts is they're not transparent. But actually, a lot of most people's conception of online courts, they may not offer real-time transparency in the sense that there's a process you can watch. But many people in this room are encouraging these online courts as never before to capture and gather and make available information about court behavior. That offers a remarkable degree of transparency. And if that was again available on a global basis, very few countries, in fact most countries pay lip service to rule of law, very few flagrantly, it seems to me, breach. But if there is the ability for others to scrutinize even data about the courts, that gives rise to, it seems to me, a new era of transparency in our global justice system. You may think it's pie in the sky, but frankly, we live at a time, as I say, where more people have access to the internet, access to justice. And so we're here today to try and think radically and differently about how it is we might improve the lot for the average person for whom the law is becoming increasingly alienated. So my suggestion is that online courts bridge this gap, which has hitherto been unbridgeable other than by lawyers and courts, between understanding one's rights and enforcing one's rights, but that we might go further and we might think about building some standard infrastructure that we can introduce globally. And that's what's going to be preoccupying me over the next few years. Anyone who's interested in joining me, please do get in touch. But again, I want to congratulate and thank DLA for assembling such a formidable audience and set of speakers, and very much look forward to the rest of the day. Thank you.